Okay, uh, I'm gonna I'm gonna get things started with some very brief remarks. First, again, a thank you from FIRE to our faculty network members and friends who are joining us this evening. Um, Usually around this time of the year, we're pretty deep in the stages of planning what would have been our fourth annual faculty conference. Um, Intervening factors have pushed that out. As they have a lot of other things with the COVID-19 pandemic. So, in the absence of being able to do our usual conference this year, we are putting together, among other things, what we hope to be a series of several webinars where we'll be able to bring our faculty network friends a little closer so that we can continue engaging them, given how many upheavals higher education has seen on various fronts this year. Without further ado, I'm going to hand over the beginning of this discussion on the new Title IX regulations to my colleague Samantha Harris, if that is all right with you, Sam.
Yeah, absolutely. Hi, everyone. Thank you for joining us. So before we get into the regulations, I want to explain a little bit about how we actually got to this point, because oftentimes, Title IX is itself a very brief law prohibiting sex discrimination in federally funded educational programs. It was part of the Education Amendments of 1972. And so, oftentimes people say, well, how did we get from, no sex discrimination in higher education to this place where we have schools running these kind of parallel judicial systems where they're adjudicating claims of sexual misconduct? So I want to just kind of give you a brief overview of that path, because, for a lot of people, it's not, and, for me, before I learned about it, it wasn't really something that was intuitive. So 1972 is when Title IX is passed, and really, it contemplated things like overt discrimination in admissions and recruitment, athletics, things like that. And then in 1977, for the first time, a court held that Title IX applied not only to these types of overt discrimination, but also to acts of quid pro quo harassment by faculty. So this was a case called Alexander v. Yale. It was decided by the District of Connecticut. And basically, what the court held, and I think it makes good sense, is that, if you are, on the basis of your sex, being asked to submit, to submit to sexual advances or to provide, sexual favors as a condition of, doing well in a class or, other types of educational achievement, that this is a form of discrimination. So that decision was 1977, and then things just sort of continued to develop slowly over the next couple of decades. But then in the mid-90s, this idea of hostile environment harassment really sort of came into the public consciousness, first through some findings of the Office for Civil Rights, and then ultimately through a series of court decisions culminating with the Supreme Court's 1999 decision in Davis v. Monroe County Board of Education. And the idea of hostile environment harassment is that, schools may be responsible under Title IX for, when they are aware of student-on-student harassment that is actually materially, preventing someone from going about their business, getting their education, that if they're aware of this and don't do anything to ameliorate it, that they may actually be, allowing discrimination to occur. Because, for example, if you're being severely harassed by someone you're in a class with, and you stop coming to class and you fail the course, and the university knows about this harassment and doesn't do anything, what the Office for Civil Rights and what the courts have said is that, when an atmosphere of harassment permeates the educational environment like that, and the school does nothing about it, that is a form of harassment that a school is responsible for addressing under Title IX. Now, of course, the question becomes, well, what does that mean, student-on-student harassment? Is it just, if someone says something offensive to another student, how do we determine what is harassment that's covered, and how do we protect the First Amendment in the process? And that's where this Supreme Court case of Davis v. Monroe County came in. And in that case, the court held that schools could be liable to students who were the victims of peer harassment, could be liable under Title IX, but only if the harassment was so severe, pervasive, and objectively offensive that it effectively denied the victim's access to an educational opportunity or benefit. So that was the Supreme Court's Davis decision, and that was how we got to the point where hostile environment harassment is really something that schools have to regulate under Title IX. And every court to look at this question has held that physical sexual assault unquestionably meets these Davis requirements. It's severe, pervasive, and objectively offensive. So that is how sexual assault on campus came to be understood as a form of sex discrimination. So, once it was decided that schools have this obligation to address peer sexual harassment, including sexual assault, they had to set up grievance procedures for doing so. And that is kind of how we got to the point where we are, not only today, but we're going to talk a little bit about, the sort of 10 years immediately preceding these regulations and sort of what changed and what happened. But that's kind of how we got to the place we are today, where schools have these grievance procedures set up for addressing sexual misconduct on campus. So now I'm going to turn it over to Joe or Robert, whichever one of you wants to discuss this, to just sort of talk a little bit about the history of FIRE's involvement and maybe a little bit about the history from 2011 to the present before we get into the substance of the regulations.
This is me officially doing not Pitt. So Robert, you're up.
Great. Thank you. And sorry, I had a little trouble getting in here. And thank you for the intro, Sam. Yeah, so FIRE's involvement from this, I'm few of us here, maybe actually all four of us here are almost, I know you're not supposed to say very unique, but somewhat unique at FIRE in that I think we all were probably here when the 2011 regulations came down, and they actually came as a pretty big surprise to FIRE. They actually came as a surprise to everybody because the Dear Colleague letter that kicked off this Title IX firestorm, one of the main problems with it, and the one that led us to ultimately file a court case challenging it, was the fact that rather than going through the notice and comment process that regulations are supposed to follow, which means that they publish exactly what they are proposing to have as a regulation, then there's a comment period, which is usually minimum 60 to 90 days, can be much longer, where the public gets to weigh in. Then they have to address all those comments, come up with a final regulation. Instead of doing that, on April 4th, 2011, the Office for Civil Rights of the Department of Education just popped out with this letter. And it starts with Dear Colleague, and it's probably, I think now, the most infamous and most well-known of all Dear Colleague letters. And it had a couple of provisions which Sam may have explained, having to do with basically making it so that you could effectively face double jeopardy if you were found not responsible for sexual assault on campus. And then it said that both sides could appeal, so that you could actually appeal a not guilty finding effectively, which is something you can't do in the criminal justice system. That actually got cemented into law on the reauthorization of the Violence Against Women Act. So actually that's still law, unfortunately, but that is the way it is right now. The other one was the mandatory lowering of the standard to the preponderance of the evidence standard, which is the 50.01% reasonable, or certainty standard. This technically, these kind of letters aren't supposed to be mandatory, but in reality, they are, particularly when they're written the way they were. And but what this really did was, even though those were the two really substantive provisions, they kicked off this really intense turning of the screws from the Department of Education and OCR, having to do with how they were going to enforce Title IX. This led to other rules done in similar sort of backdoor regulatory ways. One of which we called the Blueprint, which tried to redefine sexual harassment as any unwelcome conduct of a sexual nature, including verbal conduct. So that would mean you overhear a dirty joke and that's automatically sexual harassment. They tried to square the circle on that by saying that, oh, well, it's not hostile environment sexual harassment, which doesn't really make a lot of sense. It either is sexual harassment or it's not. But what happened was schools really started to get this signal, and they started to vigorously enforce these regulations that were not really regulations. But I think what happened was they got the message from the federal government that they were supposed to come up with some more guilty verdicts. And so effectively, that's what they started to do. And because of the low standard of evidence was, having a standard of evidence that might be higher than preponderance was one of the very few safeguards that students who were accused would have. And so FIRE got involved early on. We've always cared about due process. It's been in our mission since the beginning, but it had always been sort of a side interest of ours in some ways. And we really only took on due process cases when they related to other parts of our mission. But we realized that we very quickly realized that this was going to be a huge due process concern for so many people that were clearly not intended to, and we're not going to get a fair shake from campus justice systems. So we started to lead the fight against this. First, we tried to engage with the Department of Education. We actually met with them a time or two, but that didn't get anywhere under the Obama administration. And then when the new administration came in, the things that we'd been saying for those many years started to get actually listened to. And ultimately, the regulation that has now been, promulgated and is currently in effect, reflects a lot of what FIRE was saying needed to be done. In terms of protecting due process for students, not just the Davis standard, which Sam was talking about, which is very important, but also a lot of procedural protections you take for granted so much. Most people didn't even realize they're not there. The one that always strikes me is in our review of the top 53 or 54 U.S. News schools, more than almost 75% didn't have an explicit presumption of innocence. And that's always struck me, because if you were going to create a justice system, which is what they do in the United States, that's probably, if you've watched Law and Order or any crime show ever, that's the one thing you would think of is, oh, well, you're presumed innocent until proven guilty. The fact that more than 70% of schools didn't say that right out. Some of them will claim that, oh, well, the 50.01% means that, people have to be a little more certain, so you're technically presumed innocent, which doesn't really pass the laugh test. The fact that that was left out of so many schools' policies shows the, I think, agenda that was really enforced at schools. And so now they're dealing with this new regulatory environment, which we're going to talk about, and a lot of new questions as to how to run a campus justice system in the Title IX perspective, but also outside the Title IX perspective, that I think schools are going to, they're struggling with right now, because it really goes against, 10 years plus, probably more like 20 years of being told that all of these protections are somehow injurious to victims and injurious to those who accuse. When what was in fact happening, in our opinion, is that the system itself was being corrupted by these unreliable verdicts that were coming out, and we've seen an explosion of federal litigation against schools as well. So that's where we were. FIRE's been happy to take the lead on this. It's been a tough decade or so, lonely at the very beginning, and actually for a significant amount of the time. But we're really proud to have gotten to where we are, and at least depending on what happens politically, things could change. You never know. But the fact is, this is now part of the conversation in a way that 10 years ago, it simply wasn't. People were not thinking about this, and now they are. They're having to come to grips with what these important protections that we as lawyers particularly have been working on for the last 1,000 years, and Magna Carta level protections in some cases. Colleges are finally starting to grapple with why we have those protections and why they're important. So that's my sort of intro spiel. Next up, Joe, you want to get into a little bit more about, what the process followed and how all this occurred?
Yeah, my pleasure, Robert. And thank you all for joining us tonight. As FIRE's Legislative and Policy Director, it was largely, and first and foremost, my responsibility to steer us through the government relations process of advocating for fundamental, fairness directly with the Department of Education, to try to change how they were behaving from the point of the issuance of the Dear Colleague letter to present day. And it was a long and arduous process, and I know that Robert just took you through some of the ways that we were advocating prior to the introduction of the new regulations. But I'm going to take us a step back and now take us through that process. Back in 2017, the Department of Education formally withdrew the Dear Colleague letter and some FAQ, frequently asked questions, that they had published afterwards to explain their point of view of what was required under Title IX, which I know I'm saying their point of view, but it's a strange situation where they were trying to have their cake and eat it too, claim they weren't binding, but also testifying in Congress at the same time that they were going to take enforcement action against anyone who didn't follow their recommended procedures, which brought into serious question about whether or not they truly were recommendations or being treated as if they were binding regulatory law. So with the withdrawal of the Dear Colleague letter and the FAQ was replaced with a shorter FAQ that was a placeholder that said, we're going to revert to how things were the day before the April 4th, 2011 Dear Colleague letter, and we promise to start a full notice and comment process inviting stakeholders to the table to provide their input. And that, of course, gets kicked off formally on November 29th of 2018, when the department published in the Federal Register its proposed rule, and opened up notice and comment until January 28th of 2019. So a 90-day period for the public to weigh in. That period ended up being extended by 2 days after there were some people trying to submit comments on the deadline who claimed that they were having problems uploading their comments during a 2-hour window. So the department chose to extend the deadline by 48 hours once they were confident that that had been resolved. After the notice and comment process, which solicited over 120,000 comments, not all of them unique. Some of them were the same as, copy and paste from a postcard type of comment. But after 120,000 comments were submitted, the Department of Education reviews those comments and then has a legal obligation to evaluate the substantive comments it received and produce a updated rule, which it then sends to OMB, the Office of Management and Budget within the White House, for its consideration. And OMB looks at it to make sure that it's consistent with the current administration's policies, and an eye towards whether or not there's anything in it that contradicts what other agencies are doing. And it opens up another, period where public can flag any additional things that might have been missed during the notice and comment process. Now, right when this OMB process was started, a draft of revisions to the rule were leaked and comment upon in the New York Times. Now, no one could be sure whether or not it was what the final rule was going to look like, whether or not it was the contemporaneous draft that was being sent to OMB, or whether it was a draft from 2 weeks, 3 weeks earlier. But there were a few small changes in the rule, when it went to OMB, which then invited folks to comment on an OMB. And we were amongst many groups that requested a meeting with OMB to flag some of our ongoing concerns with the proposed regs, because while we were happy with a vast majority of the proposal, there were a few ways that we identified that it could be improved, and we wanted to make sure that the department, we used every opportunity that we had to communicate to the administration what the ideal rule would look like. OMB had the regulations for somewhere between 4 months and 6 months. And during this time, they didn't set a deadline. It was just, it went to OMB, and it was posted that you could request meetings. And every time it got to 1 or 2 days before the deadline, a new group would request a meeting that would be set 2 weeks out. And it looked an awful lot like it was intentional obstruction, which was later demonstrated when a Title IX coordinator from Tulane University posted on YouTube bragging about it being obstruction coordinated by the National Women's Law Center as a plan to delay the regs as much as possible and maybe prevent them from ever coming into effect by continually requesting new meetings. Now, the one thing to remember is the OMB process is actually optional and isn't binding. So the department didn't have to respond to anyone who requested for meetings, didn't have to grant those meetings, but chose to anyway. So there was a tremendous amount of feedback that the Department of Education received when formulating the rules. What they're legally obligated to do with that feedback is produce a final rule that at least responds and explains why they agreed with criticism and made changes, or why they disagreed with criticisms and stayed how they were. And they're obligated not to do that with absolute perfection, but they can't just blow and ignore, if they get tons of comments on a particular facet and just not address those issues. And that's, one of the things that was at issue recently in the United States Supreme Court in the litigation over DACA, and whether or not the administration could have repealed DACA, and did they explain why they repealed it thoroughly enough and address the criticisms they received there. And this similar kind of analysis that you'd see here. So, so that was the overall process of what was of how the department had to come up with the regs and what went into it. What I can say is that the department has received both praise and criticism for the length of the regulations. Now, the overall document was about 2,034 pages. And 2,034 pages sounds like a pair of G.R.R. Martin novels. But what it really was roughly 34 pages of actual regulation and almost exactly 2,000 pages of addressing those 120,000 comments, which they were legally obligated to do. Now, folks can debate whether or not they could have used tighter language and been more grammatically shorter and used an editor's pen to make sure there weren't any excess clauses to shrink down the length of it. But the truth was they were going to have to produce an extraordinarily meaty document to meet the legal obligations of substantively engaging with the input that it received. So that's kind of the overall summary of that process. Excuse me. Before I kick it over to my colleague, Samantha, I want to talk a little bit about some of the non-procedural protection aspects of the regulations, but important aspects of the regulations nevertheless. So one of the most important features of the regulations from my perspective, and I think, I speak, for FIRE when I say this, is that the department's new regulations do a great job of one thing in particular, which is turning the focus of Title IX back onto what we believe was its intended purpose, which is making sure that students have continued access to education. So you hear from victims' rights advocacy groups all the time that it's not, that it's about equal access and therefore the criminal justice standards don't apply. But the conclusion to be drawn from the fact that it's not, that it's about the equal access is that it isn't really supposed to be about the punitive process per se. Not that the punitive process isn't an important aspect of addressing harassment on campus, but the most important focus of Title IX was supposed to be about making sure that students have an environment where they can continue to learn. So the Department of Education do something that's very important with regard to that by saying no matter what happens, whether or not a formal complaint is filed, whether or not a student can prove in a adjudicative process the truth of their allegations, the school has an ongoing obligation to continue to provide support services to a complainant to make sure that they can continue their studies. And this makes total sense. Just because someone can't prove that they were raped doesn't mean that something didn't happen that is affecting how they can learn. Doesn't mean they shouldn't have ongoing access to counseling. If you think that someone was raped by someone in their chemistry lab, it shouldn't matter whether they can prove the case to determine whether or not they really should be separated, for example. Or if they think someone alleges that they were raped by someone in their dormitory building, you probably don't want them being stuck in an elevator alone together or being in the laundry room together in the basement either. So making it absolutely abundantly clear that schools have an obligation to be considering the question of what supportive measures are necessary for a complainant to be able to continue to receive their education, regardless of what happens in the adjudication process, is a tremendously important development here and one that is going to be a great benefit to complainants in our opinion. The other non-procedural aspects of Title IX I'll try to cover quickly so we can kick it over to Samantha to go over the procedural aspects, include one thing that has received both praise and criticism for, and that's it restored the jurisdictional limits of Title IX. In the case that Samantha referred to, Davis versus Monroe County Board of Education, in addition to setting forth the definition of peer-on-peer sexual harassment, the case also expressly talked about the limits of schools' authority under Title IX. And it made clear the school only has authority over disputes that arise out of conflicts that come out of situations where they have control over both the students who are involved and the context and locations where it took place. It had to be inside the programs and activities, which wasn't so restrictive as to mean that if anything ever happened off of campus, it was always completely off limits. So for example, if there was an alleged rape at a fraternity party, if the school had a regulated fraternity system that was part of the program and activities, if a cheerleader or a band member alleged that a football player raped them on a trip for a game, that also was within the programs and activities because they were there. All of the students were in that location because of the programs and activities. So it wasn't quite as restrictive as some of the critics would describe. Another way that the regulations looked towards the case law to establish the jurisdiction was that Davis versus Monroe County Board of Education also says that schools only have to address the things that they have actual knowledge about. And they're only in the wrong when they fail to address, are deliberately indifferent towards behavior that meets the standard that they define later in the case, that Sam covered in her opening remarks that occurred in the programs and activities that they had actual knowledge of. And the reason is because you're talking about whether or not a school has an obligation to stop something that they themselves weren't doing. And the court points out they themselves are a bad actor if they ignore things that they know about. But they're not a bad actor if they don't know about it in the first place. So the actual knowledge prong comes directly from the case itself. And then, of course, the last thing, and I want to revert to just for 1 minute before I turn it back over to Sam, is that the case of Davis versus Monroe County defines peer-on-peer harassment under Title IX. And the department wisely used that definition, which is on the basis of the protected class, gender, objectively offensive to a reasonable person, severe and pervasive, such that it prevents the target from equal access to one of the benefits and opportunities that the school was providing. And all of those prongs are equally important. And too many schools across the country had not been following that decision. Last thing I will say about that is that the Department of Education itself had indicated through documents that it had published in 2001 and again in 2003 that having the same standard for liability and for enforcement made sense, which makes double sense when you read the actual decision of the case itself, which doesn't just talk about liability, but also talks about the fact that they had to set a standard in a place that wasn't going to encourage schools just to avoid liability to infringe on people's constitutional rights. They have this entire exchange between the dissent and the majority in the case that talks about setting the lines intentionally where they did to protect these constitutional rights. So the Department of Education had for years said that having a multiplicity of definitions didn't make sense and that they needed to have definitions consistent with Davis versus Monroe County Board of Education. And while prior generations of the Department of Education were playing it a little loose and fast in that they were almost copying Davis, but changing it in one way, they were expressly declaring that they acknowledged that it had to be consistent with Davis versus Monroe. Now, we've always thought that it had to be exactly Davis versus Monroe County Board of Education, and we're so pleased to see the department having done that here. And I think that that sums up what I wanted to talk about in terms of the non-procedural aspects of the regulations. I know I've been talking to you for a while. I want to kick it over now to my colleague Samantha to go into all of the other things that are provided in the regs that will make the procedures more fair.
And if I could just jump in for a moment, I'm going to just give attendees here something I should have given at the outset of the meeting, which is just guidance on the question and answer portion of this. The best way to deliver your questions, and you can do this at any time in the meeting, if you click down on the Q&A field in your menu bar, you can type out your questions anonymously or not that way. And we will do our best to get to answering each and every one during the question and answer portion. If you have questions that you'd like to ask any of us outside the scope of this meeting, I will give all of our email addresses. They're easy. It's basically our first name at thefire.org. But I will put that all in the chat field to you so that you can contact the panelists from this meeting outside the scope of the webinar if you like. But yeah, in the meantime, feel free to be adding your questions to the Q&A field as you like. And now with that said, I'm going to hand it back over to you. Thank you.
Okay. And Peter, do we have a hard stop at 7? I want to make sure I leave time for questions and also for Robert to give a legal update.
We're on till 7:30, so we're good. We're good on time, I think.
Okay. Okay. Terrific. All right. I see a question came in. So let me see before I start talking. Many university Title IX officers oppose these revisions and have made clear that they intend to continue abusing the rights of the accused on behalf of complainants. what options do faculty and students have to bring enforcement actions against their own Title IX offices? Well, I mean, I can answer that. So there's sort of what the thing you're talking about could happen in one of two ways. One of the more concerning trends that I have seen is that universities are sort of trying to circumvent the regulations in ways that are not actually illegal, in the sense that they've adopted the regulations for Title IX for what they call Title IX sexual harassment. But then they say, if you commit other types of sexual harassment, meaning like harassment that fits a broader definition than Davis that the university defines, that they can route that through their ordinary code of conduct. Or even some schools have said that, conduct that violates a Title IX policy may also violate a code of conduct and could still be addressed that way, which might give schools sort of two bites at the apple, one where they have to provide these procedural protections and one where they don't. And I think that's sort of an evolving issue that we're going to have to deal with. If a school simply violates Title IX, the regulations in the adjudication of a Title IX complaint, then the faculty or student can file a complaint with the Office for Civil Rights. I actually just did this. In addition to working at FIRE, I also have a private law practice where I do mostly campus disciplinary stuff. And I actually just filed a complaint with the Office for Civil Rights on behalf of one of my clients, because even before the regulations took effect, and when the Department of Education rescinded the Dear Colleague letter, it put into place this sort of interim guidance on handling sexual misconduct complaints. And one of the things in that interim guidance was a requirement of meaningful notice. So that, I'm going to talk about this notice requirement in the regs too, but basically it said, when you give someone notice of a Title IX violation, you have to tell them who is accusing them, if that's information is known, when and where the misconduct allegedly happened, a detailed description of the conduct allegedly violating the policy, because a lot of schools weren't doing this. And so, in my case, some of the allegations against my client involved, and they were all sort of allegations stemming from his classroom pedagogy, but because he teaches a sexual behavior class, some of them were statements that allegedly related to sex or gender, so they fall under Title IX. And the school didn't give him any of that required notice. And we asked for it, and we said, hey, this guidance requires this. You need to provide us with this. They didn't do it. So we actually filed a complaint with the Office for Civil Rights, which they're now investigating. So that would be the recourse if your school is actually violating these regulations in the adjudication of complaint. The problem is going to be how to deal with these two-track systems that technically don't violate the regulations, because the school says, well, this isn't Title IX, this is just us, enforcing our own conduct code. And there, you may have various remedies, either in contract or at a public university, under the due process clause. So hopefully that answered your question. And I think, that some of what I'm about to talk about may also. So if that didn't quite answer it, and I don't answer it in what I'm going to say now, then let me know. So one of the most significant aspects of the regulations is the fact that they require Title IX cases to be adjudicated using fair procedures. This has been a huge issue in Title IX adjudications for many years now. When the Department of Education issued the 2011 Dear Colleague letter, it not only reduced procedural protections, which Joe talked a bit about, but it also ushered in an era of aggressive enforcement. And this isn't to say that campus disciplinary procedures were all hunky-dory before that. I mean, FIRE was started in 1999, and since our inception, we have been receiving complaints about the lack of due process in campus tribunals. But something clearly did change in 2011, because starting then there was a dramatic increase in the number of complaints from students and faculty claiming that they were denied a fair process in Title IX cases. And in fact, since 2011, more than 600 students have actually filed lawsuits over this. So with the advocacy of FIRE and other groups, and with this onslaught of litigation, the issue of due process in campus Title IX tribunals finally started getting some much needed attention. And because of all the lawsuits, a patchwork of case law began to emerge where your rights in a Title IX proceeding kind of depended on where you were. Some courts ruled that due process required a live hearing with cross-examination. Others haven't ruled on that. So it kind of fell to the Department of Education to standardize the rights of students under what is a federal statute. And in addition to that, the department also has an obligation to ensure that constitutional rights are not being violated in the implementation of Title IX. And yet many courts were finding that this is exactly what was happening. So when it crafted the new Title IX regulations, the department included a number of important procedural protections, many of which reflect what was already happening in the case law around campus due process. One of the most important things to understand is that these procedural protections benefit both complainants and respondents. For one thing, they preserve the integrity of the process, and this leads both to more trustworthy results and to results that are less likely to be overturned by an appeals board or a court, which of course, if you're a complainant, is a horrible thing to have happen. If you have a meritorious claim and you find that it's overturned because the tribunal that heard it violated the accused student's due process rights, and this is something that's happened. And what's more, all of these protections themselves maximize the truth-seeking function of the process, which is something that benefits both parties. So starting out sort of from the beginning of the protections, from sort of the earliest stage of the process, as I kind of mentioned when I was answering that question, the regulations require meaningful notice in advance of a first meeting. And that includes the identity of the parties, the date and location of the events in question, and a description of the conduct that allegedly violated university policy. And believe it or not, universities have often not been providing this information. We regularly see students and faculty called into meetings knowing nothing more than that someone has accused them of sexual misconduct. And it's really unfair. There's really no justification for it, but it happens all the time. And the regulations also require that the notice include a statement that the respondent is presumed innocent. The next important thing is that at the college and university level, this isn't true of K-12, which has some variations in terms of these regulations, but at colleges and universities, Title IX procedures have to include a live hearing with the opportunity for cross-examination through the parties' advisors. And this goes for both students and faculty. It's really hard to overstate the significance of this. For many years, a lot of schools have been using a single investigator model, where instead of a hearing, you just have one investigator who interviews the parties and witnesses and makes a decision without any kind of live proceeding where the parties appear together. And one judge who ruled on a case and ruled that Brandeis University's single investigator model was unfair, described the problems with it in a way that I think really encapsulates it. So I'm just going to quote it. He wrote, quote, "The dangers of combining in a single individual the power to investigate, prosecute, and convict with little effective power of review are obvious. No matter how well-intentioned, such a person may have preconceptions and biases, may make mistakes, and may reach premature conclusions," end quote. So, it's really hard. It's also really hard to challenge someone's credibility when there's no live proceeding. And this goes for both parties, the complainant and the respondent. This is something I've seen up close and personal since I started my own practice earlier this year. When your client has the opportunity to address the panel directly, to hear from the other party, and to address inconsistencies in the other party's story, the process is much fairer. So much so that it's kind of hard for me to understand how in good faith people would oppose it. The opportunity for cross-examination is also very important, again, for both parties. If there are inconsistencies in one party's story, you need a way to be able to address these. And asking them through a third party like a hearing officer who can kind of modify or exclude questions as they see fit just isn't sufficient. The cross-examination requirement is one that has generated a lot of criticism from people, largely because they worry that it will re-traumatize victims and make them less likely to come forward. And this was actually something I was asked about last week when I testified before Congress about these regulations. And I'll say now what I said then. Any process, whether you have a single investigator model or a hearing process. Any process can be conducted sensitively or insensitively. A single investigator could certainly be insensitive or even cruel to both complainants or respondents, or they could be very thoughtful and ethical. And similarly, a hearing process with cross-examination could be conducted sensitively or insensitively. And it's really incumbent on schools to ensure that any adjudication process that they employ is conducted sensitively. It's not like schools can't have rules about the conduct and the deportment of advisors conducting cross-examination. And quite frankly, as someone who does these cross-examinations myself and who knows many of the other attorneys in this sort of relatively small group of people who specialize in this work, I think that the fear of that these disciplinary proceedings are suddenly going to be filled with, hostile attorneys grilling young complainants is relatively unfounded. Everyone I know who does this work is incredibly sensitive to the complexities of these situations. The regulations also guarantee both parties access to all of the evidence that the university has gathered, and not just the evidence that they intend to use in the proceeding. And this is something that's critically important too. Until the regs, a lot of schools would only give students access to the investigative report or to the investigator's summary of witness statements, rather than to all of the evidence and statements themselves. And when the parties can only review these summaries, they often don't get to see important evidence that might help them make their case. Sometimes universities simply don't think something important is relevant, or other times they knowingly or recklessly leave key exculpatory or inculpatory evidence out of an investigative report. This is something we've seen repeatedly in the cases that address this. And so either way, allowing the parties to see all of the evidence greatly increases the fairness of the process. In a lot of ways, the increased transparency is a theme throughout these regulations. We see it on the provisions in notice and access to evidence. We also see it in what the regulations have to say about universities' training materials. Over the years, there have been many allegations that the materials that universities use to train Title IX investigators and hearing panelists are not appropriate training materials for individuals whose job it is to be neutral. So, for example, at Stanford, FIRE uncovered the fact that the university was using materials that were really intended for victim advocates. They were using them to train their adjudicators. So these were materials that said things like being persuasive and logical is a sign of guilt. And I always liken this to, the fact that you can't give a jury instructions that might prejudice that jury because they have to judge the case, exclusively the case in front of them. So even if it were true, for example, that 99% of accused murderers were guilty, if you told a jury about to hear a murder case that 99% of accused murderers were guilty, that would be considered prejudicial, because the question is not what, statistically, is this person likely to be guilty? The question is, on the facts and evidence before me, is this person guilty? So this is the problem with a lot of these training materials. And universities have kept these under a really tight lid. The only way that FIRE and other organizations have been able to get access to some of these are through either freedom of information requests or through litigation discovery. But now the regulations require universities to make these training materials publicly available on their websites. Another important feature of the regulations, and it's not quite a procedural protection, but I think it's worth mentioning, is that they restore the option for informal resolution, which is something that the previous Department of Education had actually forbidden in cases of sexual misconduct. And there are important safeguards in place in the regulations to make sure that this is truly voluntary. So first of all, it can only be offered after a formal complaint is filed. And this is so that schools can't just try to keep their numbers down by pressuring people to engage in informal resolution instead of filing a complaint. And students also have to be advised of all of their options in writing, and they have to give written consent. So while it might seem odd that students would want to engage in informal resolution in cases of sexual misconduct, it's important to understand that a lot of campus sexual misconduct doesn't necessarily look like what we think of when we hear the term sexual misconduct. There obviously are criminal sexual assaults that happen on campus, but there are also a lot of cases arising from sexual miscommunications or failures to communicate that leave two people with very different understandings of what happened during a sexual encounter. when I was at a meeting a few years ago that included a number of university attorneys, I was very interested to hear them say that that they wished that informal resolution was an option, because a lot of complainants don't necessarily want to see the other party kicked out of school. They just want to have some kind of reckoning or some kind of opportunity to discuss what happened and to let the other party know in what feels like a safe setting how this has affected them. So with a formal judicial process as the only option, the impression I got from these attorneys is that they felt that there were complainants who likely didn't come forward at all because they didn't want to put the other party through that. And then, of course, you had others who did come forward, and the formal process was their only option. And you had students who were expelled from school over miscommunications that could likely have been worked through in an educational way. So in this way, the option of informal resolution gives more control back to complainants to address things in the way that I think feels right to them. So that's kind of a brief overview of the procedural protections in the regulations. I mean, there's a lot more to it, but obviously there's 2,000 pages of commentary. So, if you have questions about any of these specific points, I'm happy to answer them. But otherwise, I'm going to turn it over, I think now, to my colleague Robert, who's going to talk about the legal challenges that have been brought to the regulations and where those stand.
Yeah, thank you. And I'll try to keep it short. And if people have questions, I can get deeper into it, because this is really, it got pretty complicated. So Joe mentioned that there were 2,000 pages of 2,034 pages of regulation, 2,000 of which was answering the various comments. Well, the same folks who brought you the 120,000 comments and the resulting 2,000 pages of answer have also, I think, it seems pretty clear that there's been a coordinated effort to bring multiple federal lawsuits in multiple jurisdictions to try to delay, and now that that's too late, ultimately overturn the regulations. There are actually 4 cases that have been filed, 4 federal lawsuits. One in the District of DC, one in the District of Maryland, one in the Southern District of New York, and one in the District of Massachusetts. And while the defendants are the same in all that, it's either Secretary DeVos or the Department of Education, or some combination of that. The plaintiffs are different. The case that was filed in the District of Columbia the District of Columbia was filed by 18 attorneys general from most of the blue states. Basically, they're all Democrat attorneys general, plus the DC attorney general. And then one other case by an attorney general, the New York attorney general, filed by themselves in the Southern District of New York, which is New York City. And then in the District of Maryland, the ACLU filed a lawsuit against not the procedural protections that Sam's been discussing, but against the use of the Davis standard. And then in the District of Massachusetts, the National Women's Law Center and some other victims / accusers rights groups have filed lawsuits there. Fire, we knew this would happen. There was not just telegraphed, but also an obvious strategy that was going to be pursued. And so Fire has filed to intervene in each of those cases. And what intervention means, legally speaking, is that Fire would sort of join as a defendant alongside the Department of Education in those cases, with a slightly different argument. And our argument is that the use of the First Amendment protective standards and these due process standards isn't just a policy choice, which is more or less which is exactly what the Department of Education said. Federal agencies are always trying to defend their ability to change their minds and have discretion and that sort of thing. Our argument is that actually they don't have discretion to do things that are speech protective, or to mandate these procedures that protect these fundamental due process rights, that they have to do those things, that when they decided to regulate on it, they actually didn't have a choice. So here's how. So our intervention petition was granted in the District of DC. It's been rejected in 2 other ones, and I think we may maybe all three other ones. And we are appealing where they've been rejected. They were rejected in New York, I know. I was rejected in Massachusetts. I'm not sure Maryland has actually, the ACLU case has actually ruled on that yet. So we've appealed our denial of intervention in those two. We are an active part of the District of DC case, which has the advantage of it's the one with, it's the big case with all of the attorneys general. But if any of the strategy here is to try to go for an injunction that would overturn the regulations, and the people challenging it would get 4 bites of the apple, 4 different chances to get a judge who sympathizes with their argument. The judge in the District of DC, so the first argument, by the way, in 3 out of 4 of these cases, not the ACLU case, was that there should be an injunction that prevents the regulations even from going into effect. The District of DC judge ruled on this and said, no, I'm not going to do that. The District of New York judge also said that he wasn't going to do it. The District of Massachusetts person basically waited too long. It was clear that it wasn't going to happen. It could have happened right up until it became in effect. But that one, so basically in those 3 cases, the idea of this temporary restraining order, this very quick injunction that would prevent the regs from ever going into effect, that's now done because the regs have gone into effect and they're in effect nationwide currently. However, all of those are going to start proceeding to the next phase, which may be a trial phase, may be a discovery phase, although there's not a lot of things to discover here. There's not a lot of dispute over the facts of what happened. What we're arguing over is whether or not the regulation was validly put in place. So we're in sort of 4 different procedural, well, a couple of different procedural postures, maybe 3, and there's 4 different cases. So you can find all this if you go to FIRE's website. If you're a legal junkie, if you go to our legal section, there's a box that's FIRE. It's a section that says Fire Defense Title IX regulations, and you can read all of the latest pleadings that have been done there. So this will likely continue. I mean, just the reality of it is. Vice President Biden has promised, he's made a campaign promise to revoke the regulations if he is elected. That is something that, since the executive put out the regulations, the executive can issue new regulations that would get rid of the old regulations. It's not as simple as reversing a Dear Colleague letter. There would have to be a regulatory process, but certainly that's something they could do. The other possibility, however, that may be complicated by the fact that FIRE is involved in at least one of the cases already, and we're going to be making arguments that say that some of these things, even if they could even if the executive could withdraw these regulations, we might still be able to vindicate the principle that when these things are that there's constitutional principles that dictate how these things are handled. And so that's the reason FIRE's intervention here is so important. But again, there's 4 chances to get a judge who might decide that they didn't answer all of the comments, or that the regulations are arbitrary and capricious. Reading Ouija boards and tea leaves is always tough with cases like this, and I don't really want to speculate on how it comes out. I would say that the fact that, as Joe was saying, they did do 2,000 pages of answering. I think the best argument against this would be, and the one that they're frequently making is that they didn't, really consider all of the factors. I think that's a tough argument to make when you're looking at 2,000 pages of answers about the comments. I think that's a tough one. So that's where we are on that. FIRE is going to continue to fight this. We have a partner in Speech First and the Independent Women's Law Center who have joined us in most of these cases. And, I won't say we're looking forward to litigation, but we are determined and we are going forward with it. This is a very important issue for FIRE, and it's something that, we are going to be, trying very hard to do. And I think, given the complexity, given the constitutional concerns behind these regulations, even the argument that a new administration has the authority to replace these regulations with whatever they want, I think is a very tough argument to make. I'm not sure that is an open and shut case. I think it's not an open and shut case, as a matter of fact. So these are all arguments that, we will figure out, how to deploy and what to say when the time comes. So, but I don't think there's anything there that, people would not expect. These kind of regulatory cases over regulations are very common. Administrative law experts do this kind of thing all the time. Often there's billions of dollars at stake, if it's an oil regulation or something like that. So, this is an area of law that, while it isn't usually applied in the educational context like this, is one that's well established, in the way things are handled are well established. So it's just we're gonna have to play out the process.
Joe gave me a nudge, and I think he may have had something he wanted to add on top of Robert's point. Joe, are you there?
Thanks, Peter. I think towards the tail end of what Robert was saying, he hit on what I was thinking, which is that it's not completely obvious what powers new administrations have to just do a wholesale swap and replace, and you saw that a little bit again with the DACA fight, in terms of having an administration that wanted to repeal that policy, and a Supreme Court ruling that said that they hadn't done so properly, and that they couldn't, at least not how they had done it. And I hesitate to speak for Fire when Robert is right here, but I think that he can correct me if I'm wrong, but Fire will look for every opportunity that we have to defend, fundamental fairness and effective enforcement of Title IX, including, looking at all of the legal theories that are available to us, both as challenges to the regs and should there be a future president, in terms of what we can do to defend these norms.
Yeah, that's right. I mean, we're not making very novel arguments here in terms of the constitutional argument. The argument that the First Amendment should apply to these kind of actions, especially when so much of what is defined as sexual misconduct is sexual harassment that is verbal in nature, that is, either oral or written. It's words, it's expression. This is something, to the extent that can be regulated, that is a core constitutional issue. And those aren't the sort of things that courts blithely set aside. And so, it's going to be an interesting, I think, as the arguments develop, it's going to be interesting to see what our opponents in these cases come up with. It'll also remain to be seen whether or not all four of them continue. If President Trump is reelected, that obviously makes the road for the opponents more difficult. Maybe not legally speaking, but in practical terms. And so it's just it's always a roll of the dice to some extent in terms of when you go to court. But I think I hope this doesn't jig us, I would rather be us than them at this particular time. I think the arguments we're making are, they're not just legally correct, but I think they appeal to that sense of justice and fairness, and the way that Americans traditionally, and the Anglo-American system even more traditionally, handle these serious accusations of abuses. This is something that has been treated far too casually for far too long, and it's really heartening to see a recognition of that at the highest levels here with these new regulations, to say that, these procedures are not going to be kangaroo courts anymore. They're going to be hearings where people can feel like, results are reliable. I think a critical thing is what Sam said. I think this is something that I've explained, and this tends to blow people's minds sometimes when I explain it in speeches or talks that I give about the Title IX regulations, but something that Sam said, I want to emphasize, and it's, for those who, for everybody, but, particularly for those who might engage in discussion on their campuses about Title IX, is the fact that juries and fact finders are supposed to look at the case before them and not be prejudiced by the assumptions that go on around them. Like Sam said, if 99 of 100 accused murderers happen to actually be guilty, that doesn't mean that the one you don't know whether the person in front of you is one of the 99 or if it's the one. It's the same sort of fallacy to assume that means this person must be guilty. It's the same fallacy. Most people think that if you flip a coin 9 times and it comes up heads every time, then it's got to come up tails the 10th time. That's not true. It's actually still 50-50. The odds haven't changed at all. You don't know whether you're looking at their heads or tails when you are the fact finder in these cases. And so the idea that, and we've seen this over and over, that acting persuasive and logical is a sign of guilt, or a lot of times we see these assumptions are just bald statements that people in fraternities are more likely to engage in sexual assault. These sort of broad stereotypes, frankly, a lot of them racial stereotypes as well. Those things are not informative when you are the person who has to decide whether that human individual in front of you is actually guilty of what they're accused of. And I think that's so important to remember, because the opposite of doing that is literally the definition of prejudice. And yet so many colleges have trained Title IX people and frankly their students to actually engage their prejudices when they're dealing with cases with accusations like this. And I think it's manifestly unjust, but it's kind of hard to wrap your mind around sometimes. If anybody has any more questions, we'd love to entertain them. You can put them in the Q&A. Happy to answer them. We still got a few minutes. Peter?
Yeah, well, just to repeat what Robert said, anyone here who has a question they'd like to ask can throw it in the Q&A. I thought maybe I would ask just one question, and it might be best for Joe, but maybe any of you could answer. But it's something that I know sort of exists in this realm of general Title IX concerns, and how faculty have sometimes felt like the man in the middle on these. Is I know that there have been some cases where faculty have been worried and felt hamstrung by being in the position of being required to report, of mandatory reporting provisions for when they think that they may have some knowledge of a potential Title IX violation. I know that's it's something that we have had a number of inquiries from faculty over the years, people who have felt kind of caught out on that aspect of these policies. So I thought maybe for our faculty who are listening in, if we had any thoughts on that you might be able to articulate.
I do have some thoughts on that, and I'll try to make them brief. And Sam or Robert, please add in anything that you'd like as well. The proposed regs, the regs that are now in effect, I'm so used to calling them proposed regs. The regs that are now in effect don't change tremendously the law around who is and is not a mandatory reporter. Under both pre and post regulations framework, schools largely got the opportunity to define who amongst their employees had a legal obligation to report allegations that came to their attention up the chain. And they would label those people a responsible employee. One thing that was always true was that it was crucially important that schools make sure students know who is and who is not one of those responsible employees. So if they want to find a shoulder, that they can rely upon without triggering the whole apparatus, they know and can make an informed decision about who to speak to. There are a lot of advocates, and I think FIRE has been persuaded by this point, that it's unwise to make faculty mandatory reporters because you want that first contact. Faculty have so much contact with students, someone who they have a relationship with, and by relationship I'm not talking about a romantic relationship, but they know and interact with all of the time. And we want students to feel comfortable in approaching the person who they interface with all of the time from the university to just speak their mind and seek advice and counsel. So we've tended to encourage schools to not make faculty mandatory reporters. Now, two things I'd like to add about that. One is that some states have chosen to make different categories of employees mandatory reporters. If any of you are in Texas, Texas passed a extraordinarily broad bill, wildly unconstitutional in that it defines peer-on-peer harassment entirely subjectively, not at all using the Davis standards. It's clearly preempted by the federal regs in that respect. But it also says that every employee of the school, and I repeat, every employee of the school is a mandatory reporter, and that it is a misdemeanor, criminal misdemeanor, if they don't report it up to a Title IX coordinator once they have any knowledge of a potential violation of their entirely subjective definition of peer-on-peer harassment. And it also requires that any of their employees that don't report up the chain are automatically terminated for failure to do so. So that's a little warning about Texas. The only other thing that I want to add about this is that there's some confusion about this concept of mandatory reporting because there are two contexts where it comes up. The first is the one we've just been discussing, who has an obligation to report things up the chain. But the second is about whether or not the school has an obligation or the right to tell law enforcement once it's come to their attention. And FIRE has made the argument, I've written an op-ed called The Case for Mandatory Reporting years ago, that said that once a school administration is aware, they should at least loop in law enforcement so they can reach out to the student and offer their support and offer the services that they provide. The student can always hang up on law enforcement or tell them to take a hike, but we think it's dangerous for law enforcement not to be looped in at that stage. So that's the basics of what I think about when I think about mandatory reporting. I know there's something else that I'm forgetting to say, but I think that covers the basics.
Thank you, Joe. Sam or Robert, anything to add on top of Joe's very helpful answer?
No, nothing.
Okay. Well, we still have some time for questions. If anyone else wants to throw some into the queue, if we're short on questions, I don't want to be the professor who keeps everyone to the end of class just on principle. I had plenty of those, and I don't want to become one myself. In the event that we don't have any additional questions, Robert, Sam, Joe. I do see one has come in. Question: what steps can be taken to inform students or faculty of their rights on these issues? One of you want to take that question?
Well, I mean, look, I think that the work that FIRE and other due process advocacy groups are doing is really important, because a lot of it is just, as you say, sort of knowing your rights. I mean, schools are required, obviously, to publish their Title IX policies, and generally they do provide both complainants and respondents in these cases with sort of a list of rights and responsibilities. But it is really important, I think, for groups that care about these things to be sort of sounding the alarm about this, not only for students who are already on campus, but for people who are considering where to go. So for example, this at a public school, you have due process rights. At a private school, you don't. That may not be something that is of great concern to you when you're choosing a college. But, knowing what I know, I would probably favor, for example, my children having constitutional due process rights in college. So I think it's important to get the word out not only to the people who are on campus, but also to the general public, so that this can sort of be on their radar screen. You know, I mean, I always say people look at all sorts of things, you know, faculty student ratio, you know, dorms, things like that. Well, you know, looking at what rights you have on campus, and most schools do publish their student handbooks. I mean, these are things you can find out in advance. And I wish more people would sort of vote with their feet and insist that schools provide these rights, because I think that until that happens, schools are just going to keep taking advantage.
Thank you.
I agree with everything that Sam said. The one thing that I would also say I think is so helpful is for people on the ground at schools who talk about these issues to not talk about it always in a framework of us versus them, of due process or victims' rights, but to talk about how we need systems that think seriously about how to do right by all of the people that are involved, and that it isn't okay to cut corners in either of the two directions. I think that being that adult in the room that demonstrates that we care about this from everyone's perspective is vitally important to being heard when we are talking about something that's really unpopular, the rights of people who are accused of sexual misconduct. I mean, it's you know, a lot of people naturally line up against someone, you know, who they think is, you know, might be a sexual predator. So so making sure that we emphasize how it's important to everyone is really crucial.
Thanks very much, Joe and Sam. I'll make one last call for questions, but again, I won't force the matter. Again, people are. I've given out all of our individual emails for anyone who wants to talk further with any of us. You have me, Peter at thefire.org, Joe at thefire.org, Samantha at thefire.org, Robert at thefire.org. Pretty easy, but I've also left it in the chat for people to take note of. And if and I think not seeing you know, without further questioning, I do see you know, I'm happy to talk with you more privately about this, Professor. I know you and I have had some conversations on this. If that's okay, I may keep that going just outside the realm of this webinar. And yeah, if there aren't any further questions, I think I'm gonna, so to speak, dismiss class just a little bit early today. I'll make a couple quick final remarks. First, just again, to our faculty network members who tuned in, thank you so much. This is you know, the first in what I hope is going to be several of these on a variety of topics that we put together for our faculty network members, where we will bring together our network members, not just with my fellow experts on the fire staff, but with some of their own peers to talk about their own work and their own advocacy. You know, I hope that we will be announcing a good number more of these in the coming weeks. This was my first time hosting one of these for Fire, so I'm glad to notch my first to get my first notch in the belt. I definitely learned something from managing this webinar. And just again, to our faculty network colleagues, keep your eyes out for your email. We're developing a lot of new resources and scaling up our efforts significantly this year for faculty. You know, this has been, in higher education, in so many ways, a strange year. It's been, in some alarming ways, a kind of record-setting year at Fire in terms of with everything going on, with all the external shocks that higher education has faced. You know, the number of case submissions and inquiries we've received went through the roof during the summer. You know, I think the need for Fire's resources for faculty is at a high point, and we're doing our best to respond to that challenge. So I thank all of you for tuning in. I look forward to sharing more of our future offerings with you. And thank you all so much. And especially thank you to Robert Shibley, Joe Cohn, and Samantha Harris. Truly three of kind of the reigning experts on this issue and the legislative and procedural history of the Title IX regulations. Like Robert said at the outset, this was something I think we were pretty much all around at the outset, and it's crazy to think that nearly a decade has passed since that April 2011 Dear Colleague letter. So thanks very much to all of them for lending their time and lending their expertise on the topic. And I won't belabor the topic further. I'm happy to say good evening to you all. Again, thanks to my colleagues. Again, thank you to our faculty network members. And take care. And again, if you have any last questions, feel free to reach out to any of us individually. We'll be happy to talk further.
Thanks, everyone.